All right, so this is the last video before you turn in your final pretrial memorandum. First, we're going to talk about the submission instructions, which are posted on Canvas. Then we're going to learn a little bit from the drafts and talk about explanation and application. I have a few things I want to say from questions that I've been asked during the conferences. And then we're going to review editing and polishing. Submission instructions. Content. You must turn in every part of the pretrial memorandum, which includes the caption, the title, the perfunctory language, the introduction and its subtitle, the statement of facts, with its subtitle, the argument section with its subtitle, the entire CREAC, the conclusion section with its subtitle, the signature block, and the certificate of service. Your pretrial memorandum is due electronically no later than 11:59 p.m. Sunday, February 2nd, 2025. A hard copy of that assignment is due to me before the start of class on Tuesday, February 4th. If you are late for class, then your submission of the hard copy is going to be late to me, so do not be late for class. Your word count is 2,350 words. No credit will be given for any material that runs over this limit, and you will incur an additional penalty. The certificate of service and the signature block, including the respectfully submitted, is not included in your word count. On Tuesday in class, I showed you everything that's included in the word count. Make sure that your word count is accurate. Formatting, you must satisfy all of the requirements from the sample. Your font must be 12-point Times New Roman, including any text that occurs in the footnote, including the footnote number. You must use 1-inch margins. You must left justify the margins. You must use 1-inch margins on all sides. You must have page numbers. Those page numbers need to be at the bottom center of each page, and those page numbers need to be in 12-point Times New Roman. All of your titles and all of your subheadings must be bold, underlined, and centered, noting that the title of your document is only underlined for the last line. You must have a point heading. That point heading must be single-space, bolded, and in all capital letters. You must double space your entire document with no extra space in between paragraphs other than the double spacing. The only thing that should be single spaced is the title of your document, the point heading, the signature block, any quote that is 50 words or longer, and any footnote that you may have. Let me just say this again. You should not have footnotes, but if you do have footnotes, they must be single spaced. On the last page of your memorandum, underneath the certificate of service, you must include a sentence that certifies the number of words in your document. And your citations must be in Blue Book form. You must identify the source of authority, including pin site information for any point that is not your own thought. Please remember that these are just the highlights. For the specifics of the submission instructions, please see the submission instructions themselves. They are posted on Canvas. You will be held responsible for following them. So let's talk a little bit about your pretrial memos. We're going to start with hooks. You're going to be scored on hooks using this criteria. Uses hooks which accurately and persuasively represent the subject of each paragraph and demonstrate the relevance of the subject to the main issue. What does that mean? It means that your hook should expand upon the rule or explain the rule further. It should not be a recitation of the rule. So here are some sample hooks. I'll tell you what I think. First one, officers must follow outlined police procedures so as not to violate a citizen's right. There is no citation after this hook. I don't know what this hook is explaining or what this explanation paragraph is about. Nowhere in here does it explain that there is an inventory search involved, just that officers must follow outlined procedures so they don't violate a citizen's right. It does not help explain the rule, nor does it expand upon the rule. When officers conduct inventory searches and fail to adhere to standardized procedures, the search becomes invalid. Well, other than the fact that this is in passive voice, there is a cite after it, which is good. Please note that my citations in this example have the case names underlined. I do that just so that you can see it so it looks a little bit different. Remember from last semester, it is my preference that you get into the habit of italicizing your case names. I do that just because in practice, you are more than likely going to be expected to italicize your case names, so you might as well start here. An inventory search is invalid when an officer fails to follow established department procedure. It's a little bit better. I'm not sure that it really expands upon the rule as much as it basically talks about the second part of the governing rule. I do want to bring up that your signals and your case names should be in the same typeface. So if you'll see here, you will see that the C is italicized and the case name is underlined. Do not do that. If you're going to underline your case names, then your signals need to be underlined. If you're going to italicize your case names, then your signals need to be italicized. They need to be the same. Now we will talk a bit about analogic reasoning. Looking at your samples, this would be representative of how you all are doing the facts, holding, and reasonings for a case. And my response to you is, I wonder why you are struggling with word counts. Recognizing that there is no hook, this is just the FHR. In United States v. Rigby, the officer, part of a tactical robbery unit, TRU, claimed to have seen the defendant not wearing a seatbelt. Period, full cite, and it's not the full cite because they are actually citing to the order and not to the report and recommendation, and it's missing part of the cite. The officer saw the defendant park the vehicle in a tow-away area, get out and lock the car. As the defendant was walking away, the TRU surrounded the vehicle. The officer conducted a records check and unprompted got up and tried to open the locked driver's side door of the vehicle. The officer asked for the keys, and when the defendant went to reach for them, the officer placed him in handcuffs. The officers, after finding evidence of criminal activity, did not properly fill out the required police forms, nor had they, prior to searching the vehicle, gotten the defendant's consent to impound the vehicle. The court held that the officers decided to impound the car in bad faith and improperly searched the vehicle. No cite for that. That's a lot of words with a lot of facts that you don't need to make the point that you're trying to make. So let's see an FHR revised. In Rigby, officers followed a suspect for a traffic violation. Again, the cite is not right because it doesn't have the report and recommendations, but we're just going to leave it as it is for now. After the suspect exited the vehicle, the officers surrounded it, and one officer attempted to open the locked driver's side door. The officer asked the suspect for the keys and then took the keys from the suspect's pocket and began searching the vehicle prior to impounding it, putting together two sentences from the previous. This officer also failed to complete the required police inventory form. The court held that the officer entirely failed to follow department inventory procedures, rendering the search invalid. This cut out almost half of the words from the previous FHR. So please make sure you are focusing on the facts that are necessary when you are doing your FHRs. It will help with your word count. Remember that every hook needs to be supported by a minimum of 2 cases. Please note, I am not saying that you have to have 2 cases per hook. There will be time where you have 3, there will be time where you have 5. But each hook must be supported by a minimum of 2 cases. Sometimes that comes out to be an FHR and an explanatory parenthetical. When you do that, you need to make sure that your explanatory parenthetical relates to the hook. You can't just give me an explanatory parenthetical and have it talk about something that was not involved in the paragraph itself. Here we have a hook. Although officers have some discretion in conducting a search, where an officer's statements and actions indicate that the failure to fully comply with investigatory search procedures resulted from an intent to engage in an investigatory search, courts find that the search violates the Fourth Amendment. Of course, as always, the hook will be followed by a citation. Now, after you have done an FHR, if you want to add an additional support, you could add an explanatory parenthetical. So here we have an explanatory parenthetical to Rigby. Again, the site is not including the report and recommendations, just so I can get it to fit on a slide. And there should not be a period after the 24 right there. But holding that an officer's premature search and failure to complete the inventory form, coupled with statements before and during the search, indicated that her failure to follow proper protocol was motivated by an intent to find contraband, established the purported inventory search violated the Fourth Amendment. So that relates to the hook. We're not talking about the failure to impound a car. We're just talking about how if you act on certain ways, it may imply an intent for an investigatory search. So for those of you that may have forgotten, let's talk about explanatory parentheticals for a second. You must start with a present participle, which is an ing word, holding, noting, finding, explaining, anything that a court would do. The only exceptions to that is 1, if you're using explanatory parentheticals to enumerate a series of examples, or 2, if you're using a full quote sentence as your explanatory parenthetical, you're quoting the case. Other than that, it must begin with an ing word. Remember when you draft your explanatory parentheticals that you begin with a lowercase letter, that you provide specific facts. You need to refer to the facts of that case because the reader is not necessarily going to read the case and they need to know why the case is there. You must give specific context. If you cannot do your explanatory parenthetical in a single sentence, then it needs to be an FHR and not an explanatory parenthetical. And there is no ending punctuation within the parenthetical itself. The punctuation will come after the parenthetical. As a reminder, you use an explanatory parenthetical anytime that you use a signal other than no signal, which means if you have a C also, a contra, a CF, you are going to have an explanatory parenthetical after that case. Now we are leaving the explanation and we are moving to the application. Remember that for application, you are giving the rule by means of case illustration and the facts. And because of that rule and because of your facts, the court should do what you want it to do. But you must tie in your facts to the rule, and that rule usually comes from your case illustrations. You always want to explain the why to the reader. Don't expect them to make the connection themselves. A clear application section is what wins or loses cases. Why? Because you and your opponent start with the absolute same rule or same law. You and your opponent have the absolute same facts. You and your opponent are both trying to convince the reader that your position is correct. So having a good, clear, strong application section to show the court that the law is on your side is what's going to win the case for you. So, if the point of analysis, which all application paragraphs should mirror the explanation paragraph, so where the explanation paragraph started with hooks, your application paragraph should start with points of analysis, is Officer Lantana did not follow proper procedure because she did not fully check the car and because she failed to wait until Mr. Balin had fully authorized the impound of his vehicle. It's a little bit clunky, but at least there's a point of analysis. Now, this is a student, I did not write this, application section. Similar to the officers in Rigby, Officer Lantana did not properly fill out the impound inventory form because she failed to check the spare tire compartment. You would need cites after that sentence. The Coral Gardens Bay Police impound inventory requirements state, that's a mouthful. I would have hoped that in your facts you have limited that. A vehicle is to be completely inventoried at the scene of the impoundment. Again, you would need a cite. Additionally, Officer Lantana, like the officers in Rigby, failed to follow proper procedure by not confirming with Mr. Balin if someone was going to pick up the vehicle before beginning the inventory of the vehicle. Why is that relevant if you've admitted that she had the authority to impound? That's just my question. Officer Lantana states, wrong tense, that she had already begun listing items within the car as well as the appearance of the outside of the car before allowing Mr. Balin to respond to her question. Similarly to Rigby, the court should grant the motion to suppress because of Officer Lantana's obvious failure to follow proper police protocol for impound and inventory searches. Take the obvious out. We're not going to use obvious intensifiers as a persuasive tool because it is not persuasive. Nowhere in this paragraph did the writer tell me what happened in Rigby other than similar to. So let's see how you can revise that. Or first, remember that your goal is to describe facts that are legally significant from Rigby to those in yours and explain how those facts lead to the conclusion that you want. You want to show your work. It's like long division. So, like the officers in Rigby whose failure to follow procedures resulted in an invalid search, at least we have told the reader something. Officer Lantana's failure to follow proper procedure by starting her search prematurely and conducting an incomplete and poorly documented search makes her search invalid. There's our first analogy. Now we get into specifics. Officer Lantana improperly began her search of the vehicle, including listing items in the vehicle before Mr. Balin consented to towing it. And there's a cite. Moreover, Officer Lantana did not check the spare tire compartment and did not accurately complete the inventory form. And there's a cite. So you've gone from just making a big statement to specifically pointing out where the failures were. Based on these significant deficiencies, the procedures used in conducting the search, the court should find the search does not fall within the inventory exception to the Fourth Amendment. I would cite to Rigby there to support that. But other than that, that is how you do analogies. Remember that you need to cite in your application section. You must cite to the documents from your simulation as well as citing to law. You can use either a citation sentence or a citation clause. I am going to tell you straight up that my preference is citation sentences because I think citation clauses make a sentence hard to read, therefore whittling down the point you are trying to make. But I will discuss both. So this would be a citation sentence where you say something like in Rigby where, and you give whatever facts you want from Rigby here, comma, you give whatever facts you want. When the sentence is over, you add a period, and then you cite to Rigby. You don't need a C because you use the name of the case in the sentence. Rigby, give the cite, semicolon. Now you cite specifically to where that can be found in your document. If you want to use the citation clause, you can use it two different places. Like in Rigby where, when you're finished with the facts of Rigby, you can then give the cite to where in Rigby those facts are found. Here, and then you give your facts and make your comparison, and you give the cite to where it's found in your facts. Or you can do like in Rigby and give the cite in Rigby, and then give the facts from Rigby here, and then give the facts from the depot. Again, citation clauses are not wrong. The Blue Book acknowledges them. That said, they do take away from the persuasion because it makes it harder to follow your point. Because I will ask all of you, when you are reading in your casebook, how many times do you skip over when you see citations? So you may miss part of a sentence because you were skipping over the citations when you are reading. So it limits the effectiveness of the sentence you are saying. Certain concerns from the conferences will make it as a true or false. The cover memo from Elizabeth Isaacs is part of your record and can be relied on and cited to in your memorandum. The answer to that is false. The cover memo from Elizabeth Isaacs is part of attorney-client work product. If you were going to make it as part of your record, you have now opened the work product doctrine and allowed people to get your attorney notes for a case, and you don't ever want to do that. True or false, you may bring up a case in the application section of your argument that was not addressed in the R or E of your argument. Again, that is false. You cannot introduce any new law in your application section. It needed to have been provided or given to the reader in the R or the E before you can rely or discuss it in your A. And if you mention or use 3 cases to support a hook concept in your E, you must use all 3 cases to support that concept in the A. That is not true. Sometimes you will use a C also to help make a point in the E. You don't need to rely on the C also. That said, an application concept should also not be supported by a single case. Final persuasive tips. Remember that if you use key phrases and repetition, it helps to make your point. That does not mean that you should be cutting and pasting sentences and reusing them, but key phrases can be used for emphasis. Make sure that you check your sentence and your paragraph length. You want to use short sentences and you don't want any full page paragraphs. Placement of where you put information is important. Remember the beginning and end of a sentence and the beginning and end of a paragraph have more persuasion than stuff that's stuck in the middle of the paragraph or the sentence. And make sure that you write in favor of your client. When we edit and we polish, the first thing we want to look for is to make sure that our paper doesn't sound like a bunch of bullet points. So we want to use transitions. Your textbook, page 292, has a bunch of transitions. Transitions help you understand the relationship between what came before and what is coming next. They are not filler. They should not be used as filler, but they should be used so that people understand how things are flowing. So if you were going to use a transition that you were adding to a thought, you would use so, and, furthermore, in addition, then. If you're comparing, you could put both, likewise. If you're contrasting, you could use but, while, instead, despite, however, notwithstanding. If you're conceding, you could put although, even though, or though. If you are using something just for illustration, for instance, in particular, for example. And if you are summarizing, accordingly, thus, and therefore. For transitions, go to page 292 of your book. For those of you that are worried about word counts, let's see if we can get some of the throat clearing out of your writing. What do I mean by throat clearing? It is prudent to note that. Totally unnecessary. You can just start with courts consider. It is settled law that the government cannot. No, just say the government cannot. Based on the previously discussed cases, we can see that the government acted improperly. Well, if you've been talking about the cases, you don't need to say based on those cases. I don't know who the we is. You in the court is never a we. So you could just say the government acted improperly. And people also throw clear by saying things like, in a case very similar to ours. No, there is no our. You are talking to the court. You and the court don't share anything. Be careful with vague references. Make sure the reader knows what you are referring to. So don't do things like, because the government cannot establish the first and second purpose. No, because the government cannot establish, and then you say what those first and second purposes are. Officer Lantana had involvement in the relevant events. No, tell me what the relevant events are. In this case, it likely will be. What does it stand for? I don't know. Be really careful with your pronouns to make sure it's clear who a pronoun refers to. Cut back on your verbosity. Be concise. Do not say the courts have determined that there are 3 justifications for the government engaging in an inventory search. All you have to say is there are 3 justifications for the government engaging in an inventory search. When you give the cite at the end of it, it will show that the courts have determined. Courts have identified 3 purposes for an inventory search. No. The 3 purposes of an inventory search are, take that stuff out. Don't tell me you need to cut an argument because you don't have enough words when you are keeping all these words that don't say anything in your writing. Remember that in the explanation, instead of using defendant, plaintiff, use relationship nouns. How does the person relate to the case? And remember that everything that happened in your explanation has already happened, so you should be writing in past tense. Do not refer to Mr. Balin as the defendant. That is not going to be persuasive on your behalf. Refer to him as Mr. Balin. Do not use contractions. When you are referring to the court that you are filing your motion and memo before, refer to it as this court as opposed to the court. Always remember that court is singular. If you say courts find, I better see at least 2 cites after that sentence. Do not cite to the cover memo. If you mention a fact in your application section, that fact must be in your statement of facts. That said, if you mention a fact in your statement of fact, it does not have to be in your application if that fact furthers the story. Again, be careful with pronouns and vague references. Pointers for writing, no page-long paragraphs, use short sentences. Limit the use of quotes and of pronouns. Can you tell that I don't like pronouns? Avoid acronyms. I did give you permission to use CGBPD for Coral Gardens Bay Police Department, just because I know that you all are going to complain and it's 5 words, so I'm turning that into 1. Consider me nice. Do not write in first person, especially when you are writing to the court. Do not use verbs like think, believe, and feel. Nobody cares what you think, what you believe, or what you feel. And courts don't think, believe, or feel. Use active voice. You can use the zombie test for that to determine unless passive voice is useful to help minimize a bad fact. Make sure that your memo is consistent throughout. Check for verbosity. Use positive language, avoid double negatives because that turns it into a positive. Edit and edit again. When you edit, make sure that you focus. Review your conclusion. Review that conclusion against your point heading. Make sure they are the same. Make sure your first C is the same as your last C, which is the same conclusion as your point heading, which is the same conclusion as your transition between the E and the A. Make sure that you pay attention to your emphasis. Compare your E and your A. Put them side by side and make sure that they're talking about the same thing. Make sure that you're addressing the weaknesses in your case as well, because if you don't, I promise you that the government will. Make sure that your paper flows. Make sure that you are providing transitions for the paper to flow. Make sure that you polish your paper. Bring subjects and verbs close together so the reader can follow what you're talking about. Make sure you minimize passive voice and nominalization. Make sure that you revise unwieldy sentences, meaning that if your sentence is longer than 3 words, find a way to either cut words out or longer than 3 lines. Find a way to cut words out or make it into 2 sentences. Make sure you also polish for credibility, which means that you need to proofread your document. You can use spell check and grammar check from Word, remembering that spell check won't find the difference between trail and trial or untied and united. It is helpful if you can print and read your document from paper. You can use a colored piece of paper to cover everything but the line you're reading. It will make it clearer. Read your document out loud. For some reason, the brain trips over grammatically incorrect sentences. So if you find when you're reading something aloud that you can't get through it, perhaps there's something wrong with the sentence. Make sure you check your citations. Make sure that your citations are in accordance with the Blue Book. Make sure that every citation has a pin cite. Knowing that when I check citations, every error is a ding on the sheet. You don't get a free ding once you've made the mistake once. It's not over. No, it counts throughout your entire paper. And on that, just a reminder that your draft is due Sunday by 11:59. It is worth 100, not your draft, your final memo is due Sunday at 11:59. It is worth 100 points. The hard copy is due before the start of class on Tuesday. Do not slip it under my door on Monday. If I walk in my office on Tuesday and there's a bunch of papers underneath my door, I'm not sure what I'm going to do, but it doesn't guarantee that I have them. You should be handing your paper in to me directly on Tuesday before class. That could be either in my office when I get there or before class starts on Tuesday. Good luck. I will see you all at open office hours on Saturday.